Good evening. Buenas tardes. Good evening, members of Planning Commission. My name is Juan Quevedo, carpenter from Norcal Carpenters. I come before you to advocate for the implementation of fair wages on upcoming development projects within our city of West Sacramento. These area standards, including fair wages, that means healthcare, accredited apprenticeship or training when you finish the apprenticeship, and also retirement. Local hire are essential to ensure the crowd benefit to all residents by prioritizing the well-being of our community and creating opportunities for everyone to thrive. I ask you to consider these standards as a vital steps towards a more equitable and prosperous future for the city of West Sacramento. Thank you. Gracias. Thank you for your time. Thank you.
Thank you.
No additional at this.
All right, thank you very much. All right, moving on to item number 2, correspondence and staff communication from the Planning Commission Secretary.
Yes, you should have a memo from Elijah and also 2 public comments in front of you. And he will go into those during his presentation.
Okay, thank you. All right, and item number 3, disclosure of any ex parte communications from anyone on the commission? No? No? Thank you. All right, moving on to item number 4, public hearings. Public hearing regarding proposed amendment to Municipal Code Title 17 for housing element implementation.
Good evening, Chair Delgado and members of the commission. So the item for your consideration tonight is a housing element implementation item to ensure the city maintains compliance with state housing element law. Next slide, please. The governing legislation requiring this change is AB 1397, which amended the California State Government Code to require by right approval of projects on low and very low income carryover sites if 20% or more of the project's total units are affordable to lower income households. By right approval means the project would be a permitted use and would not require a use permit or other discretionary review. Carryover means the site was contained in 2 or more consecutive housing element planning cycles. The overarching goal of this legislation is to remove barriers to affordable housing development on sites that have remained vacant for multiple housing element cycles. Next slide, please. So AB 1397 was passed in 2017, and it said that the next time the city updates its housing element, we must include a program to achieve compliance with the law. And so we did, and in 2021, the city completed its housing element update, and included in that update was Program 1.14, specifically designed to address the requirements of AB 1397. I do want to note that the Housing Element Update project was adopted by the City Council in 2021 after 2 public workshops before the Economic Development and Housing Commission, 2 public workshops before the Planning Commission, and a public workshop before the City Council. Slide, please. So as stated in the memo that you all received prior to tonight's meeting, the city did receive a letter of inquiry from HCD regarding Program 1.14 and the compliance with AB 1397. The letter details that failure to implement the program and required zoning amendment will result in the city being found out of compliance with housing element law. There are a number of potential consequences with being found out of compliance, including loss of certain state-provided funding, referral to the Attorney General's office, financial penalties, and application of the builder's remedy under the Housing Accountability Act. Next slide, please. So how will this amendment actually affect a potential project? Well, it comes down to projects that are proposing to build fully residential projects, meaning no commercial component, in the city's mixed-use zones. As you're aware, the intention of mixed-use zones is to provide for a mix of uses, and this is usually done by providing commercial or other non-residential uses on the ground floor and residential units on upper stories. In order to build a fully residential project in a mixed-use zone, a conditional use permit is required. However, this amendment would remove the conditional use permit requirement if the project is located on a lower income carryover site and if at least 20% of the total units in the project are affordable. Next slide, please. So it's important to note that in our case, our 3 identified lower income carryover sites are all zoned waterfront, which already allow for residential development by right and do not require a use permit. So in regards to the development rights for these 3 parcels specifically, nothing will be changing at this time. However, remembering that this legislation applies to carryover sites in 2 or more consecutive inventories, this amendment will start to come into play as the city moves through future housing element updates. So this amendment really acts as sort of a rolling program for our lower income sites, gradually removing the conditional use permit requirements for lower income properties in the inventory if they remain vacant for too long. So this is not an across the board removal of conditional use permit requirements. It's going to happen gradually. And it'll happen specifically every 8 years as the city updates its housing element. A new list of parcels will become lower income carryover and will then have the benefits of foregoing that conditional use permit requirement. So that concludes my presentation. I'm happy to answer any questions the commission may have. And I do want to note that we also have Raul Huerta and David Tilley from the Economic Development and Housing Department available to provide some additional context if needed, and specific questions that you may have about the housing element and the site's inventory process. Thank you.
All right. At this time, I think I will open it up to public comment before allowing questions from the commission. Do we have any public comment?
I'm on item 4. However, we just received one that they would like to comment on an item not on the agenda. Is that?
I believe we've missed that boat. So that'll have to come at the next commission meeting.
Okay. Thank you.
All right. Then with no public comment, I will open it up to questions from the commission for staff.
You mentioned that it will be a gradual phase out. That's a pretty vague term. Can you define that for us, please?
Yeah, absolutely. So the city is required to update its housing element every 8 years. That's a statutory requirement that's in the California Government Code, often referred to as housing element law. And what happens every 8 years as part of that housing element update process is an update to the site's inventory. And so what this proposed amendment is addressing is really specific parcels called out in that site's inventory. So that's why I mentioned it's going to happen gradually every 8 years as the city adopts and certifies a new housing element. We're going to have a new list of parcels here that could be eligible under this zoning code amendment.
Okay, so then are these 3 parcels in the presentations 3 that this would then apply to in this particular instance?
That's correct.
Okay. And of these 3, are there, other than these 3, how many residential only projects are currently being proposed in the city or with our parcel?
So we don't currently have any applications considered on these 3 properties. I can't speak to how many applications we have on other properties in the city. I'd have to get back to you on that. But regarding these 3 properties specifically, we haven't received any formal applications today. I know in the past, we've had applicants kind of come and go with interest in these properties, but we don't have anything currently that we're working on.
Okay. And then is the purpose of this then, this revision to try and expedite the development of low income or income housing on these parcels, or?
Ultimately, that is the intent of the legislature, to remove barriers to affordable housing development on certain properties contained in cities and counties' housing element vacant site inventories. That's correct.
And would that only apply to low income houses? So say, for example, developer comes in and says they want to develop, put some housing on, on plot 1 here, but they're not necessarily planning on making it low income housing. Mm-hmm. Then would this if this is approved and moved through, then would they also be subject to the waiver for that as well?
They would not. There's a requirement that a project being proposed has to designate 20% of the total units as affordable for lower income households to receive this benefit.
My question is kind of related to that too. Can they request to waive that 20% like other developments have?
So they can, and I think you're speaking specifically to the city's inclusionary housing requirements, which are kind of separate from this zoning amendment. But in order to receive the benefit of basically removal of that conditional use permit or requirement or by right development, under this specific amendment, they would need to designate 20% or more.
They cannot waive it.
No. Without designating 20% of the total units as affordable, they can't waive it.
Yeah.
So just to clarify, you said if it's on basically this survey that's done every 8 years, correct? And it shows up on the survey twice, two consecutive times. So over the course of 16 years, it's been vacant, no development, and it's in either, what are these locations? The central business district zoning, correct?
Yes, that's correct.
Commercial?
Mixed use zones.
Okay, all right. So only these specific CBD, CH, mixed use, neighborhood commercial, mixed use commercial, and waterfront. Only in those specific zones would this apply.
So all of those zones, excepting the waterfront zone, and the reason for that is that in the waterfront zone, 100% residential by right is actually permitted. Okay. So it's a permitted use. You can build a project that's fully residential without a use permit. The key here is that in the other mixed use zones, the CBD, the MUNC, the MUC, those are kind of more true mixed use zones that require a conditional use permit in order to build a 100% fully residential project.
Okay. And do you have a list of the other parcels that have been identified over the most recent inventory, and that would be coming up in the next? Mm-hmm. So when did this time frame start? Where are we at with? Did these just come up to that second 8-year period, and that's why we're talking about this now, or have they been kind of just sitting vacant for even longer than that?
So that's a good question. I think speaking specifically to this zoning amendment, the reason that we're coming before the commission tonight is because of the bill, AB 1397. But we do maintain a list in our current housing element and in our previous housing elements, going back 8, 16, and further, mm-hmm. Of our vacant site inventories. So you can find that. We can make that available for you to kind of take a look. And we do designate in our vacant sites inventory whether or not the parcel was carried over one time from one cycle or 2 times from 2 or more cycles.
Okay. I have nothing further at this time, but I'm sure I'll have more in a minute.
So is this, does the change go beyond what's required by state law, or is it wholly consistent with what's required?
What we're proposing tonight in the amendment is strictly consistent with what the state would require.
Oh.
Put another way, it puts us in compliance with state law.
Oh. And so I haven't had a chance to read through the comment letter. I guess I guess I would like a minute to read through it before we decide on this.
Would it be possible to get the zoning map up on the screens for the commission?
Yeah, so we can get the zoning map up for you if that's what you want to take a look at. We also have ready for display the sites inventory for you to take a look at that as well. We can move to that. So I know it's a little hard to distinguish the different properties here, but what you're seeing here is the sites inventory that was adopted in our most recent housing element update in 2021. You can see there in the legend, the different colors are actually indicating different levels of affordability. So you'll notice that lower income housing is designated in green, and moderate income housing in blue. We did designate what we would assume as kind of somewhere in between moderate and above moderate income housing as kind of checkered pattern. And then we have our true above moderate income housing in orange.
Okay. So some of these sites are already under development, correct? Like site 91, 92,
That's correct. That's correct.
82 is, correct me if I'm wrong, but that should be Liberty, right?
Yes, that's correct.
Okay. So these wouldn't necessarily show up on another, like the next inventory because they're being developed.
So the ones that are developed would not be eligible to show up on the next inventory. That's
Okay.
correct. Any of the ones here that remain undeveloped would be rolled over, or could be rolled over, I should say, into the next inventory.
Okay. But yeah, I'm looking at Google Maps and I see that 91 actually has houses on it, so we expect that to drop off in 2029 when you do the survey, right?
Yeah, that's correct. So any of the parcels here that you're noticing that we have active developments on that are already constructed would fall off of the inventory and be updated and removed during the next housing element update cycle.
Okay. So this is applying only to sites where a developer would come in and say, we're going to build, for example, 100 homes in this parcel, and 20 of them are going to be low to moderate income, and the rest will be market rate or above market rate. So when we're looking at something like these parcels demarcated in yellow, and it's indicated as above moderate income housing, is the expectation that we would not see this apply to those?
They wouldn't see, right, so the zoning amendment wouldn't apply to those properties. It would only apply to projects proposed on lower income sites that are carried over from 2 or more images.
So we're looking right now at basically blue and green, right?
Actually, just green.
Okay.
Blue is moderate income housing.
Just green. Okay. So that's very few sites, and if any of them are developed in the next five years or so, this wouldn't apply to them again.
Yeah, that's correct. And so as you noticed in the agenda report and in the presentation, we've only identified 3 in the Bridge District that were carried over from 2 or more consecutive cycles.
I'm just looking at the map too at the Bridge District, like for example, number 10, 9, and 8. Are those are already, apartments are there already? Are those low income housing, like 20% of them are low income housing, or those are all considered low income housing?
So I want to clarify kind of what we're looking at here in terms of the sites inventory, because primarily what this map is showing is it's demonstrating to the state of California and to HCD that we have zone capacity to accommodate a certain number of units at certain affordability levels. So you're not necessarily going to see all of the sites in green develop as affordable housing necessarily. Obviously, we hope that they will, or we would encourage developers to develop units at those affordability levels that are designated on the map here. But it's not restrictive in that way. So if there's a project being proposed here that is kind of out of line with what we're seeing here in terms of the income level and the colors here that you're seeing on the map, this is not restrictive in terms of requiring them to build units that are falling in line with this map here. It's kind of more of a capacity exercise that we have to demonstrate to the state via our housing element.
So going back to my prior question, if we had a developer who just wanted to build, something on 1, 2, or 3 parcels that you showed earlier, not making them affordable housing, can they do that with this new buy right in this area?
They wouldn't receive any benefits under this proposed zoning code amendment.
Okay.
Sorry. But the 3 that you showed earlier, those already have by right development. Those can already be developed as fully residential, right?
That's correct.
So the 3
By
that have been identified for this round, they can already do it.
That's correct.
This doesn't change anything.
That's
This
correct.
is for moving forward with, you know, when we do this again. So you did this in 2021, this is from 2021,
Yes.
was
Yep.
most recently, and then we'll do it again in 2029 and every 8 years continuing.
Yes, that's
So
correct.
basically, we take the next one, compare what was on that one to this one.
Mhm.
So this is really applying to things that have sat vacant for 16 or more years.
That's correct. Yeah. And as I mentioned previously, it is kind of, it functions as a rolling program. So every time the city updates its housing element, which is every 8 years, we're going to have a new list of parcels that we're going to be removing from this map here and adding new ones. And that's when we're going to start to see that list kind of grow of properties that could receive benefits under this amendment.
Can you explain how these lots in particular received the designation for low-income housing? I'm kind of curious because it reminds me of a question that was brought up in a previous meeting when I think it was a public comment that was made by someone about having a high concentration of low-income housing in one area. And from what I'm seeing here, even though where the majority of the lots that are designated for low-income housing are currently on this map, a lot of them are down in the Bridge District, but there's a lot of non-low-income housing in the Bridge District as well. It's just kind of, it seems a little bit concerning to me that we have all these other sites that are in that area also. It seems like it's a pretty high concentration in one area and not necessarily dispersed throughout the city.
Yeah, I think that's a great observation. It's also a great question. There is a methodology that we use to assign the income levels here to the different properties, and I'm going to actually have to turn to our housing manager, Raul, to kind of speak to that because he has a lot of experience with kind of performing this analysis. But there are certain criteria that we have to demonstrate in order to designate certain properties at certain income levels.
Thank you. And Raul, while you're coming up here to add to that, could you just remind the commission at some point where the majority of the affordable housing in West Sacramento happens to be? It's not in the Bridge District.
Good evening, commissioners. So just to answer your question, the majority of the affordable housing throughout the city is located north of the canal. That's simple. I think less than 10% is located in the Southport area. And we, as much as we can, we try to encourage additional affordable housing development in the Southport area and try to limit what is being built in, especially in the Washington district. A few years ago, we didn't have as much affordable housing development in the Bridge District, but that has changed. And keep in mind, we are halfway through this housing element cycle. So back in 2021, we probably had less affordable housing in the Bridge District. But to your point, Commissioner, that is, good observation. The thing to keep in mind, and I believe Elijah already mentioned it, is that at its core, the housing element is a land use exercise, right? We get a regional housing needs allocation from the state for the Sacramento region, and every city, county gets its share of that housing needs. And we have to show capacity. So we do our best to try to distribute that capacity as we are required. But again, it doesn't mean that all of the sites that we identified as low-income sites are going to develop as low-income, or that all of the sites that are going to develop, that are designated as moderate or above moderate, that they're all going to be market rate. Some of those may actually have some affordable units. But based on the exercise that we have to go through when we are showing capacity, that was our best guesstimate, if you want to call it that, on how we could see our regional housing needs allocated, distributed as required by the state.
And can you, because I don't know what it's the purpose, but what's the purpose of the conditional use permit in the development process? Because that's what we're talking about eliminating. So I'm not sure what's the role of that, and then what would be the implications of eliminating that portion for these types of development?
Yeah, I can speak a little bit to that, and then I think I'd like to have Seamus kind of chime in on the back end as well, if that's okay, Seamus. But essentially, the conditional use permit process is a process that certain developments have to go through in order to provide for certain uses of the property. So if there's a use of a property that we perhaps think could have impacts on other property owners or other existing uses, then the city will require a conditional use permit to try to take a closer look at that. And it really allows a staff and the planning commission at a public hearing to take a closer look at some of those impacts and to try to address and mitigate some of the potential impacts that could come from certain uses in certain areas. So generally, that's kind of how the conditional use permit process works. And Seamus, I'd invite you to kind of chime in.
Yeah, you got it. And you can add conditions of approval to mitigate those impacts. And really, this came about for the mixed use areas, really trying to encourage a variety of uses. And we made it permitted by right if you have the ground floor commercial as really as a kind of a way to incentivize developers to do that. And we've kind of slowly allowed for more multifamily on the ground floor. I think there was a zoning code amendment that came before you about a year ago that Mr. Baruman took that allowed for live work on the ground floor that made it permitted by right. So yeah, I think that's pretty much it.
Well, thank you for that, because for me, that kind of raises even more questions, because if we're talking about an infill project, that already obviously then means that it has development already surrounding it, then to be able to eliminate that provision, even though it may be for low income housing, to me, it sounds like it's almost doing a disservice or an injustice to the folks that would be impacted the most that are surrounding those developments, especially in an infill type situation.
Mm-hmm. Yeah, I think I understand that concern. I think what I'd say about that is that, over the past couple of years, the state of California has viewed conditional use permits and discretionary approvals by cities and counties over housing projects as a barrier to development. And so really, ultimately, the goal of the legislation here is to try to remove some of those barriers as much as possible when the project is providing for some of that need of affordable housing.
So would these development projects need other permits, like air board permits, or so will there be mitigation requirements through other means aside from a conditional use permit?
Seamus, can you speak to that?
Potentially. It really depends on the project and site-specific aspects of it. But I think, like Mr. Ortega mentioned, the overall goal of this by HCD is to make affordable housing more streamlined, and making it permitted by right does that. I just want to take a step back a little bit and mention that this is a policy in our general plan housing element is to do this. So this has already been approved by council. This is an implementation measure, and it's also a requirement by the state. So that's why we're here tonight, is to implement the general plan that the city council approved.
Sorry, back to the question I asked earlier. Would you mind bringing up a map of the city zoning just so we could see where this would potentially apply? It's a little abstract, I think, on this map, but seeing the zoning map might be.
Yeah, so we don't have that prepared in the presentation right now, and I'm not sure if there's a way thereof for us to get that from the website. We can work on that, see if we can pull that up.
Because we're not talking about doing this like in a residential community, single families. Like we're not talking about R1 or
That's
rural
correct.
estates or anything like that. We're not talking about putting a 500 person unit apartment in the middle of rural estates, right? We're talking specifically in specific zoned locations.
We're specifically talking about the conditional use permit requirement for 100% residential projects in mixed use zones. So you'll notice mixed-use zones here on the zoning map are designated in that light blue. So you can see we have kind of a large area there south of the Deepwater Ship Channel, as well as an area there, I believe that's Yarborough down there, Sarah, and as well as a significant amount up towards Washington as well. And again, the reason for this is because of that conditional use permit requirement in the mixed use zone to build a fully residential project.
Right. And just to remind the commission, we did vote on a conditional use permit, I believe, across the street from Target a few months back. Or maybe it was longer than that, a few meetings back, something like that, where they were proposing an affordable multi-family residential complex next to the fire station. And we had to vote on that because there was going to be no commercial down on the first floor, even though it was mixed-use commercial. So we're just codifying that, correct?
That's correct. And I think that's a really good example to use because that's exactly the type of project that would benefit from this kind of amendment. So ultimately, a project like that you considered a couple months ago would, instead of coming to the Planning Commission, would be able to move straight to the building permit phase.
Can you hear me? I'd like to go ahead and make a motion to approve staff's recommendation. Thank you.
Sorry, do you mind holding off on making that motion? I just want to make sure that we're complete with discussion.
Continue discussion until somebody makes a second.
Okay. All right, we'll do that then. On that note, commissioners, are there any additional comments or questions, clarifications that you would like?
Yeah, I just have a question. We see the full table of 17-09-020. Is this the whole table? 'Cause I think there's more to it. Or is this the complete table?
Oh, are you referencing in your agenda report the zoning table, I think?
Yeah.
Okay.
Where the change is going to be made?
I would ask you to pull it up, Sarah, but there's kind of a few different steps to get there. So I think you're referencing the table of mixed use permitted uses.
Yeah, and I guess, so would this, because this change would apply to the whole table?
No,
Question mark.
we pulled out the section of the table that where this amendment would apply, and that's in bold and underlined.
Okay.
So there's some language there that you're seeing specifically regarding the housing element carryover sites. So that's the only change that we're proposing to the table. The rest that's not bold underlined is remaining the same.
So should this be like a number like the other ones and just applied to the parts it applies to?
So the numbering, the reason that we didn't do that is because this amendment is actually going to be a little bit more flexible, and that's intentional. And that's kind of, we did our best to follow kind of the guidelines that HCD put together for implementing this legislation. So I think it's a good question because I know it can get a little bit confusing here with different zones and the different lettering here and the different boxes. But we did pull out, and what you're seeing in your agenda report specifically is that bold underlined text that we're proposing to amend and place in the table here.
Yeah, so this would come at the end, right, where the like footnotes almost
Keep
are.
going. Here we go. That's correct. So now you'll be able to kind of visualize and compare and contrast there with your agenda report. And you can see there we have this section here of the zoning matrix here labeled specific limitations. And we're proposing that we kind of insert this amendment there just below number 4.
And can you clarify what you mean when you say that you intend this amendment to be more flexible?
So I'm specifically talking about, and Jameis, maybe you can help me kind of explain this. The numbering here corresponds to the permitted uses in the different zones. So you actually have to kind of go back and cross-reference here what you're looking at for the different uses. So when I say it's meant to be more flexible, is we don't want to go through each individual zone and kind of try to fit it in there, because I think in terms of formatting, it's cleaner.
The numbers are basically footnotes, and this change will apply to the whole table. So if we make changes to the table in the coming years, we don't have to go back and insert additional footnotes.
Thank you.
Thank you.
Any additional questions from any of the commissioners? And we do have Commissioner Olivares' motion still sitting.
I'll second it. This is something we've already approved as part of the housing element, and it'll make our zoning code consistent with state law.
Okay. Would you recommend a voice vote or roll call?
Roll call vote would be good.
All right, thank you.
Commissioner LeBlanc,
Aye.
Commissioner Jackson,
Aye.
Commissioner Olivares,
Hi, and I just wanted to take a moment to thank staff for their work on the staff report and also their diligence in getting timely responses to me prior to the meeting. Thank you.
Chair Delgado,
Aye.
Commissioner Linker,
Aye.
Commissioner Wong,
Aye.
All right. Thank you very much. And do you need to read the disclaimer, Seamus? No. Okay. All right. Then with that, thank you very much. We will proceed to our regular agenda, seeing none. General Administration Function Part 2. Any Commissioner communications? Thanking staff. All right. Then with that, we'll adjourn. Thank you.